Okay, good afternoon. Thank you for having stayed this long, and thank you to Ashley and Fiona for inviting me to come and speak here. My talk is fairly law-based, so I hope that is all right. I know that it's a mix of practitioners and some people here as well. So my talk's entitled "Are the Rights of the Child Recognised When Primary Carers?" and my research relates in particular to mothers when they're sentenced to imprisonment in the criminal courts of England and Wales. My background, I'm actually originally from Belfast, but was a lawyer. I worked in family and criminal cases at the Bar of England and Wales. And then I moved into academic criminology. And the first piece of research that I did and that's being published was looking at a very small sample of judges and exploring the use of personal mitigation when they're sentencing, and in particular how they deal with the concept of motherhood. People always go, well, what about dads too? Yes, of course, primary carers really, but it's easiest for research to pin it down to a category, and so I'm looking at mothers, but the same would apply to fathers who are primary carers. I think you got a sheet of stuff from me in the packs. It's not my PowerPoint, but it's got a link to that piece of research which the hAdhmaill published earlier this year. It's called Mitigating Motherhood. And my current research, I'm looking at a larger sample of judges, and I'm also talking to children of imprisoned mothers and the people caring for those children. And really what I'm trying to look at, and why I'm looking at those two different things, is to consider the position of the children in the sentencing process from within a child's rights framework. Because at the moment, in the family courts, when we deal with children, there's a very welfarist approach to them. And in the criminal court, where they appear either as offenders or are collateral, as in sentencing cases, what seems to be attached is almost a secondary stigma to them, and for some reason they are thought not worthy of consideration. And so I am trying to find out from judges what they're actually doing, find out from children what the experience actually is to have a primary carer imprisoned, and then to somehow, as Albie was talking this morning about the South African way of thinking about it, to situate children's rights within the sentencing process, not under the category of personal mitigation, so that it's no longer linked to the offender. They're actually seen as people in their own right who come into it. So I'm going to just tell you about the situation in England and Wales. We share a legal system in those two countries. Scotland's different, Northern Ireland's different. If I say UK, I don't mean UK, I mean England and Wales, but I may get bored with keeping repeating those two bits. And in fact, all the women's prisons are in England, so we have no women kept in prison in Wales. At the moment, we do have a number of pieces of legislation that already deal with this, theoretically. So the Human Rights Act from 1998, incorporating the European Convention on Human Rights, has in it Article 8, respect to family life. And although at the moment there's a lot of debate in the UK about whether the Human Rights Act is something that people want to get rid of or keep, that is there and is referred to quite frequently in case law. We've also, as you have, got the United Nations Convention on the Rights of the Child, and the 3 articles, as were mentioned earlier this morning, I think it was by Tanya, Article 2 about non-discrimination, and in fact it's further than that. It's not just that children shouldn't be discriminated against, it's that the state has a duty to protect children from discrimination or punishment that they might suffer because of the status or activities of their parents, which seems to me to be absolutely opposite when you come to the sentencing of parents. Article 3, the best interests of the child should be considered in any matter concerning the child, and Article 12, the child's voice should be heard. There is also case law on this. I've listed a number of cases which are on my handout, I think, so no need to note them down. But from as far back as 2001, the Court of Appeal in England has been saying quite clearly that when a parent of a dependent child comes to be sentenced, the court should be performing what they call an Article 8 balancing exercise, that the state can only interfere if there is a legitimate reason for that interference, and the interference that it makes with the child's right should be proportionate. And the courts have actually said that there can be no interference that is much more serious than separating a child from their primary carer. So we have all of that already acknowledged in case law. In terms of sentencing guidelines, which is very much how the courts deal with sentencing now, the children come under personal mitigation. So there's a list of mitigating factors which a court can take into account, and it says carer for dependent children in there. That's as much of a mention as it gets there. So from all of those things that we already have in place, the principles that there are for sentencing parents are that the criminal sentencing of the parent engages the Article 8 right to respect for family life, both for the person being sentenced and for the child. As I said, the interference by the state must be in response to pressing social needs, so that's the need to maintain justice, in pursuit of a legitimate aim and in proportion. I've said about the seriousness of separating mother from a child, and then the UK has also signed up to the Bangkok rules, which say that non-custodial sentences are preferable for women, and even in the case of dangerous or serious offences, courts should still be looking at non-custodial alternatives. Now, the observations I've made from practice of what the principles are that are coming out there, firstly, it's in cases which are on the threshold between a custodial and a non-custodial sentence that understandably judges seem to think that a child's situation can tip the scales. They don't tend to think about it. Once they've made the decision to imprison, the children become almost irrelevant because they've decided to make the separation, and the length of separation doesn't concern them too much. Also, in terms of impact and tipping point, it's a child having to go into state care, and judges, again, and this research is in progress, so I'm sort of more having impressions rather than having done analysis at this point, but the impressions are that judges see family care, if they're given a name of anybody who's going to take in this child, then that's okay. They think we're okay, we've dealt with that. And they're not recognising that actually that whole sector of from being with a parent to being in state care, there's a huge spectrum, and children suffer huge disadvantage no matter how kind and lovely the person is they move in with. There are still big things going on, but that's not really recognised. And there's also no standard or normative adjustment. Now I've put possible because the view of judges is there's nothing, we can't do anything, it's not possible to change this. So what's the reality of the decisions we're getting at the moment? I've done some transcript analysis of 43 cases, 10 Crown Court cases where women with children have been sent to prison, and 33 appeal cases where the sentence has been appealed because it's a mother's been sent to prison. 23 of the women in this were single mothers, were definitely single mothers, it's mentioned in the remarks, and 12 of them it was unclear and the others had partners. Now in the appeal hearings, 26 of those 33 appeals were reduced. The sentence was reduced when it made it to the Court of Appeal. And in 20 cases, the appeal judges said this is part of the reason is because the first instance judges didn't give sufficient weight to the fact of the children. So that's quite a large percentage. I'm just skimming on this research that I've already done that you've got the link for. Find a couple of big things in it. One is that if a judge gets a pre-sentence report, which I don't know what the situation is in Ireland, but in England it's discretionary. A judge can decide whether or not they want it, and probation is very, very overstretched. So judges make decisions about how useful they think it's going to be to them. But if they do have a pre-sentence report, it does increase the likelihood of the children's needs being taken into account. It doesn't mean the judge will follow the recommendations, but in those cases it's much more likely that children will be mentioned in the sentencing remarks, and it does tend to mitigate the sentence. There's also a lack of consistency, that judges have no standards that are set, that are regular. It's very much discretion. So I just have these two quotes from judges. One said, across a range of judges, certain factors will appear as mitigating elements to some more than others. Some people will take a much tougher line on the sort of actions have consequences. You've hurt your family, but that's part of the responsibility you must bear. Others may take the view that I do not want the system to disadvantage these children in the longer term. So I'm therefore going to very significantly mitigate the sentence with the children in mind. And that judge very accurately described the two polar opposite positions that we have and everything in between. Another judge, when I said, do you consider children as personal mitigation, said, personal mitigation is of minimal significance. The only thing that really counts is the guilty plea. This is just, because I've no pictures, this is a little diagram that I produced. I was trying to understand what are judges thinking, what is affecting their decision making. And the top left, judicial experience, knowledge and personal feelings, and their understanding of the gendered pains of imprisonment below that. Those two things are entirely subjective, but every judge brings those to their decision making. And one of the findings I made in my preliminary research was that if judges already have some understanding of the impact of imprisonment on families, so for example, they've been barristers working in the family courts, or they sit as a judge hearing care cases, they understand what it looks like when families are separated. If they don't have any of that prior knowledge, they are the judges who are less likely to ask for pre-sentence reports. So it's a case of those who already understand a bit know they need more information. Those who don't have any appreciation of that don't realise the gaps in their knowledge, and so there's a sort of double jeopardy to some people. So that influences how the judges understand impact. It then determines whether they ask for pre-sentence reports. They then come to this, the judges sort of fail-safe, every case is different, we can't be standard about anything. They all say that they've got tariffs, guidelines, other personal mitigation. They then come to the influence of motherhood and then their sentence. But you can see from that that there's so much that can be different from judge to judge and case to case. So I'm also trying to build up a picture of what happens to children, what it is like for a child when their mum goes to prison, because I think judges can't be expected to take impact into account if we don't have research data on impact, and at the moment there's very little. Just to give you an idea about the UK stats, prison populations around 80,000, just under 5,000 of those are women on any one day. We keep no records of children, so we don't know how many children there are or where they are, but 2010 it was worked out there were approximately 17,240, I mean that's not very approximate, that's quite a particular number. Those children were separated from their mothers by imprisonment. We have some older stats saying a third of those mums are lone parents. Ben already said about only 9% of those children are cared for by the father during imprisonment, the other 91% we don't know, and only 5% remain within the family home. I'm sure many of you know this much more than I do, the tangible impacts of interference with their right to respect for family life. They experience significant loss, primarily of their parent, and I had a 16-year-old there who talked about the days he wants to talk to his mum and just can't. With the loss of a parent comes a change of carer, which brings with it consequential changes of home, school, routines, friends. Ben was mentioning loss of social life. All those things change. And they often enter a household which is under financial strain, an increased financial strain, because they are there. I met with some children in the summer whose mother is serving a life sentence, and they've been with their grandmother 10 years. And the 12-year-old is just starting to see bigger picture of life, and she in her interview with me told me how worried she was that Granny couldn't afford things because as she's getting bigger she's more expensive to look after, and the reality is her Granny can't afford anything. But the grandmother had no idea the child had picked up on this, but this child was really very scared about what would happen to her in the future. Also got the intangible impacts of interference, stigma and exclusion, and one of the things I'm coming up against in my interviews or finding with children is that even if other people say we don't exclude the children, we wouldn't treat them differently at school, the children self-exclude. They presume that people would. They presume it's something they can't talk about, and so they change their behaviours so that they won't find themselves in situations where someone might ask about their parent. So this boy, it was my shortest interview, it was 10 minutes because he didn't talk. And yet, when I asked him this question about what would you say to someone in your situation, his answer was like that. He didn't have to think about it for a second. He just said, lie. Well, don't lie, just don't let on the full story. He was quite sure you don't tell anybody about your parents' situation. And then we know there are longer term problems suggested by literature, mental health problems, alcohol, drug dependency, and increased likelihoods of offending. So why are we not transferring the principles to practice? We've got the statute, we've got the case law, we understand some of the impacts. I am discovering through this piece of work that those at the top of the judicial tree, so former Lord Chief Justices, Masters of the Rolls, the people who've made those important decisions saying, yes, you must be taking this into account, they think it's happening. They believe that practice mirrors principle. The Court of Appeal are level down. When cases come to them, the lawyers are addressing these points very specifically, so they bring their attention to the authorities and the Court of Appeal get it, and so they balance, and like you saw those 26 appeals where all sentence was reduced in all of those cases because the judges say yes, this balancing hasn't taken place. Then go down a level to the Crown Court, which I think is like circuit court here, and judges are dealing with a lot of cases and they don't really think it's overly relevant, and the judges I'm interviewing at the moment, I've had one out of the sample so far who has been able to tell me about any case law relating to this. So dissemination is not taking place. And magistrates, we know very little, but they are most of the short sentences. They can sentence up to 6 months imprisonment, and so they count for a lot of women in prison. But there's another researcher, Rona Epstein, working, and she picked up a case through her research where in fact the magistrates had sent a mother of some very vulnerable children to prison for an offence which is not even an imprisonable offence. So, and that was judicially reviewed, and the woman was released, but not before significant damage had occurred to her children. So that just gives a bit of an indication of where magistrates might be at with it. The question is, why are the children's rights not being considered? I think there's the lack of awareness of precedent, but to be honest, that's not much of an excuse because the Human Rights Act is there, it's very clear, it's been around a long time. There's still very prevalent the view she should have thought about that when she committed the offence, claimed benefits, did whatever it is. And there are assumptions around motherhood that criminal convictions make you a bad mother, would make you a bad parent. I had a judge the other day said some quite shocking things, which essentially equated to, if it's a family like me, if the offenders, if I can identify with them, I'll do more to try and keep the family together. If they look like a criminal family, then, well, the children are already in trouble. And there's also been an emphasis on victims over the last number of years. And so the other big thing that comes up with judges is saying, the victims, how are they going to feel? You know, those children don't have a dad anymore, so it's not right for me to take the offender's children into account, which is just missing the point entirely. So my last slide, what next? I'm doing the research, and I'm doing, hoping to get more data on the impact on the children of interference with this right, so that there can then be a discussion with judges about resituating consideration of dependent children, taking it away from being a factor in personal mitigation, saying this has nothing to do with the offender, this is about the children. Very much trying to encourage movement towards the South African model, where we look at children's rights as an entirely separate thing. But you can imagine the English judiciary is quite behind in the way it thinks. I mean, I have huge respect for judges. I think they do an incredibly difficult job very well. But we're battling against years and years and years of doing things in a particular way. Judicial education is probably a key, as is lawyer education, so that lawyers turning up representing a mother in court have the authorities and say to the judge, this is what you should be doing. Because in those situations, judges will then follow. So if you're a law student, or if you're a lawyer, make sure you've got authorities for these things. There is an increasing awareness of the needs of prisoners' children more generally, which means it's starting to get a little bit of political traction, which can only be a good thing. And I'm also involved in the Prison Reform Trust, who are doing a project on the sentencing of mothers at the moment, where we're hoping to directly address a number of judges and the Sentencing Guidelines Council about how they might start to change some of this thinking. Thank you.